Choosing an ineligible EB-5 project is a nightmare that EB-5 investors must take every effort to avoid. Under the EB-5 Reform and Integrity Act, investors may file their EB-5 petitions, the Form I-526E, with merely evidence of a filing of an EB-5 project, as evidenced by an I-956F receipt, or some proxy for the receipt, some evidence that the 956F has been duly submitted and filed with USCIS. The EB-5 Reform and Integrity Act, or the RIA, does not require that the project be approved for investors to file their I-526E petitions. Accordingly, if an investor is not careful in choosing a project that ultimately is approved by USCIS, they can invest in a project that is ultimately denied by USCIS, that I-956F may ultimately be denied if the project is not eligible. The consequences of this very unfortunate scenario is dire to investors. Eventually, the I-526E would be denied. An I-526E must be supported by an I-956F that is ultimately approved. Moreover, in concurrently filed EB-5 cases, which is often the case for investors who are already in the United States in valid non-immigrant status, such as F1, H1B, L1A, etc. The 485s may also be denied. In fact, they will be denied eventually once USCIS is able to match up the associated records of the denied 956F with the associated I-526E petitions and with their concurrently filed adjustment of status applications. And of course, the adjustment of status application is almost always filed with an application for work and travel authorization. So these interim benefits will also automatically be terminated and eventually be denied in that very unfortunate scenario. Therefore, initial project due diligence from an immigration perspective by qualified immigration advisors is critical. This is an important gating issue that all EB-5 investors must appreciate before embarking on this journey.